Good afternoon, everyone. I apologize. We're running a few minutes late. This is the executive session on pending legislation for the Senate Judiciary Committee. Can I get a motion to go into executive session?
So moved.
Moved by Senator Gannon, seconded by Senator Whitley. The first bill we're going to take up is Senate Bill 26, and I'll recognize Senator Gannon for a motion.
Motion to re-refer.
Okay, we have a motion to re-refer. Is there any discussion? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, is there a motion for the consent calendar?
So moved.
Moved by Senator Gannon, seconded by Senator Whitley. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay. Senator Gannon, will you be responsible for the floor?
I tried to be responsible.
Okay. All right. The next bill that we have is Senate Bill 38. Okay, I believe Senator Whitley, you have an amendment.
Yes, thank you very much. So I have amendment 0060 that the stakeholders worked in collaboration together on. There was just sort of an unintended consequence that they wanted to fix, so I believe it addresses the issue.
Okay, we need a motion on the bill.
On the bill?
Okay, Senator Chandley moves on to pass. Is there a second by Senator Gannon? So we're in discussion on amendment 0060S.
I move 0060S.
Okay, moved by Senator Whitley, seconded by Senator Chandley. Is there any discussion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay. Is there another motion?
Move to consent.
Second.
Nope, we need to do the bill.
Oh,
Can I get a motion on the bill as amended?
I move out to pass as amended.
Okay, Senator Whitley moves on to pass as amended. Is there any discussion on the bill as amended? Okay, seeing none.
Second.
Oh, okay, there we go. Is there any discussion on the bill as amended? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, and can I?
Consent.
Second.
Okay, we got a motion for the consent calendar. Is there any discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Okay, Senator Gannon, you want to do this one too?
Sure.
Is it yours? Okay, thank you, Senator Whitley, for the amendment. Okay, next, we have, I believe, Senate Bill 48, relative to the definition of way for the purposes of driving after revocation and suspension. We do not have to do this one right now because it's not a fiscal note bill. We have until the end of March because we have to have all the other bills done by March 30th. So there's some technical issues with this bill that we need to just kind of explore and try to figure out.
Okay.
All right.
So we're just going to hold on for this one. We won't allow to exec it. Okay. Next, we have Senate Bill 58. Senator Gannon, is there a motion on Senate Bill 58?
Yes, motion for ITL.
Okay, is there a second?
Second.
Seconded by Senator Gannon. Is there any discussion on the ITL motion? Senator Whitley?
Yeah, I'm surprised to hear that. I feel like there was a lot of people that came together. So Senator Gray's bill, I know Senator Rosenwald was really involved in it. I'm really sad to see that motion, particularly because I know it was the agreement that was reached was sort of hard fought, and I think I wanted to honor that work. So I won't be voting for the ITL.
Okay. Senator Abbas?
Thank you, Madam Chair. I appreciate all the work that went into putting this together, and I understand there was a lot of effort and really a lot of stakeholders from many different groups came to the table. I'm supporting the motion of index being to legislate because I'm looking to see when this would apply. You have to. It's a warrantless arrest. You have to be in the care of a medical professional at a medical facility. There has to be an actual or threat of violence, and it has to interfere with the providing medically necessary healthcare services. I think the medically necessary side is when that determination's made. You're asking, what you'd be asking is a police officer to make the determination of medically necessary. Now, if someone's getting a life-saving medical treatment, they're not gonna be able to be arrested anyway, is one issue. But I guess if they weren't receiving the medical treatment, they would be asked to leave, and then they would be trespassing if they didn't leave. So that's another scenario where it wouldn't apply. I just am not clear that it's appropriate for the police officer to make that determination. And it seems that when this would apply it creates kind of a gray area and can create a lot of confusion in the law. And we don't want cases being damaged by the fact that the police officers having to make that determination. And if they make the incorrect determination, you can have other problems down the road.
Madam Chair?
Yes, Senator Chandler.
I will not support the ITL either, and I guess I see this somewhat differently. I do not think that the language that says medically necessary means that it is in that moment a life or death procedure taking place. I think it means a person who is in the hospital is receiving care for whatever reason that person was brought to the hospital. And it's not necessarily the police officer making that decision. It is the medical staff making that decision. Certainly we perhaps just read this differently, but for that reason, I won't support the ITL.
Thank you, Senator. Is there any further discussion on the ITL motion on Senate Bill 58? Okay, seeing none, all in favor say aye.
Aye.
Any opposed?
No.
Okay, Senator Abbas, you can take this one out. Okay. Next, let's see, we have, moving on, we have Senate Bill 182. Again, this is not a fiscal note bill. We're going to hold on to that one.
Okay,
Because we have two bills dealing with the definition of way,
sure.
but in different places. So we just want to make sure that what we're doing is correct.
Do you want to do 180?
Oh, did I do
Are we gonna hold on
180?
180?
Oh, yes, I forgot. I'm sorry. I skipped over a couple of them. I'm sorry. Well,
80 or 180?
yeah, I get the two confused.
Me too.
Okay. So we're just gonna skip over 182. So we'll take care of that one.
Okay.
We'll go to 180. Again, this is requiring the recording of custodial interrogations and making.
Well,
an
that's
appro-
80.
Yeah, we do have 80.
Oh, I thought you said 180.
Nope,
Okay.
said
Sorry.
80. Nope, that's okay, that's right. It's like 80, 180. This one, we received some communication just this morning from the chiefs of police. So we're gonna hold off and do this one next week.
Okay, and
Okay.
I apologize for the late amendment too. That the amendment that I have is everything that the Department of Corrections requested.
Okay.
Yes, and I would still like to communicate with the Department of Corrections to make sure we got
Okay.
that part right. There is some potential conflicts with some of the language in there.
Okay.
I still see some inconsistencies that need to be worked
Okay.
out.
Okay, next we have 180. Relative to product labeling for information guide requirements for cannabis products. We have amendments.
Yeah.
So, why don't is there a motion on the underlying bill?
Yes.
Okay, Senator Gannon moves ought to pass. Is there a second? I will second it so we can discuss this. So I know Senator Whitley, you have an amendment and
Yeah.
I have an amendment as well. I think you folks got my amendment.
I did, very. So the two amendments that I want to mention, so I do have 3 amendments, but I'm gonna not discuss.
Which one?
So we can get rid of, which one, Matthew?
326.
Okay. So we'll get rid of that one. So the ones I would like to hear thoughts from the committee are 0564 and 0563. And I can tell the committee what they do.
Okay.
So starting with 0563, this was in response to an email that we all got from Kate Fry from New Futures, and
Yep.
Kate worked with Matt Simon from Prime ATC and with Michael Holt from the department. So this does a replace all, but adds the duty that I think was discussed in the bill overall, adds that duty to the Therapeutic Cannabis Medical Oversight Board. So basically says, you know, this is the board that should be making all these determinations because they're the experts. So both amendments do that. The difference between the two amendments is that 0563 creates a study committee to work on the issue further, and then the other one doesn't have that. In 0564, there's no committee, but there's also something in there suggesting a possible approach that clarifies that the hemp law was never intended to allow unregulated THC products to be sold in New Hampshire. So those are just options for the committee to consider, those two different
Okay.
approaches.
Madam Chair, from my
Yes.
perspective, I would much prefer 0564. That's my thoughts, you know, and I'm open to hearing everyone else's. I think it does what we think the bill, it attempts to solve the problem as it exists. I don't see the need to create a study committee, so I'd really prefer not to do that.
Okay,
Your preference is 0564.
Yes,
okay.
And that also includes the hemp law clarification.
right.
Because I think we heard testimony,
Right.
right, about how they're the synthetic product. So that addresses that issue also.
And Madam Chair, in
Yeah.
respect to 0564, regardless of where anyone stands on cannabis products, recreation, medical, if you're going to have synthetic THC products being sold legally in the state, but natural is not, that's a huge inconsistency in our law, which I think needs immediate attention. And I
Okay.
think this 0564 does address that.
Okay. Okay. I'm wondering, you folks have all seen my amendment.
Yes.
It's very simple. It says, no later than 90 days after the effective date, the Commissioner of the Department of Health and Human Services shall adopt rules which require the warning label on marijuana products sold via alternative treatment centers to prominently display the THC content of the product. And I think that's testimony that we heard. I think also, as with any kind of medicine, they do display these kinds of labels, and if we're going to treat this as medicine, it should be treated just like any other medicine. The other thing is that we know that children are getting into these things, and they're presenting to emergency rooms, and they have no idea what is the THC content of the medicinal marijuana that you have been prescribed. So if we can require that they prominently display the THC content, I think that would be very helpful. The second section of the amendment, it says all edible cannabis dispensed by a treatment center shall be enclosed in a child-proof container when sold. We do that with all medications. We put them in child-proof containers. Well, not all of them, a good number of them. And again, this comes back to the fact that children are getting their hands on this, and they come in the form of gummy bears or cookies or however they're sold. And you show me a child that will just eat one gummy bear. They just don't. They tend to eat more than one. And so I think this would, having these two requirements would go a long way to protecting children. So that's what I'm asking the committee to consider is Amendment 0479S. If it is the committee's intent, if we can combine 0564S with 0479S, how do you folks feel about that? Senator Abbas?
Thank you, Madam Chair. I would certainly support that, and I believe the section of 0564, that's the synthetic part, lines 17 to 21, excuse me, 17 to 20. That deals with I think addresses that's a standalone problem that I think we need to certainly do that, and I don't see how that would conflict with the other amendment, so.
And Madam Chair, I don't know if you would consider to your amendment, changing it, rather than putting it in the hands of DHHS, putting it in the oversight board. That was a suggestion made during the hearing.
Okay,
I don't know if
That's
that's
sort of the
something you
thrust of,
consider.
right, that was the thrust of my amendment too. So
So-
maybe we could put that duty
the
with them.
commissioner, okay, so the oversight board, what is the,
But they don't adopt rules, do they?
I don't know.
Is Mike Holt here?
Yeah.
Oh,
Does the oversight board adopt rules?
Why don't you come up? Yeah.
Thank you. For the record, my name is Michael Holt. I'm the administrator of the Therapeutic Cannabis Program for the Department of Health and Human Services. The TCMOB, Therapeutic Cannabis Medical Oversight Board, has a small grant of rulemaking authority about their public hearing process, but they don't have any rulemaking authority beyond that. The department has rulemaking authority for all things that you're considering.
Yes.
so,
If I may,
Yes.
I just informationally, the requirements that you're suggesting, Senator Carson, are already being met and they're required in rule. So the THC potency level is a required component of every product sold by the ATCs. In addition, every product sold by the ATCs is required by our rules to be in a child-resistant container. So the bill is redundant with what is current practice and already required in the rule.
Okay, I understand that, but why did we get testimony about things not being labeled? And why are we have kids, if they're in childproof containers, how is that happening?
The data, the report that was referenced at the public hearing was referencing a national study that did not differentiate between recreational products, illicit, unregulated products, and therapeutic cannabis products. So the report that stated 3,000 overdose deaths in the year was not broken out by state or by cause, if you will. So I've not heard of child poisonings based on New Hampshire's therapeutic cannabis products. All those products are sold with child-resistant packaging.
Okay, well then maybe we don't need the amendment if it's in rules.
Thank you for letting us know it's already in rules.
Yeah,
Appreciate
we didn't know that. Senator Abbas?
Thank you, Madam Chair. If all the amendments if it's going to fall in the Therapeutic Cannabis Board for rulemaking, I guess my concern is that synthetic products that are kind of skirting around the law, the Therapeutic Board doesn't really have any control over. They're not. That's meant to apply for medical, so I'm not sure if we want those under the same board or not. And any comment or?
I think, so from what I'm hearing, it sounds like Senator Carson's concerns are addressed. We don't need that amendment because it's already addressed in the regulation. Are you talking about my amendment?
If we were to merge them together, should,
No, I don't think we need to
No,
merge them
no.
because we don't need this amendment anymore.
Yeah, we don't need it because they do it in rules. We didn't get that testimony that these things were being done in rules. So it would be redundant if we put it into statute. They're already doing it in rules.
So we only need the one amendment.
So we're only looking at amendment 0564S.
my mistake?
Okay, so we have a motion, an underlying motion of ought to pass. We have amendment 0564S to Senate Bill 180. Is
Yeah.
there any, do we have a motion?
I will move that amendment.
Okay,
I second 0564.
thank you, Mr. Holt.
Thank you.
Okay, so we have an ought to pass motion on amendment 0564S. Is there any further discussion? None? Okay, seeing none, all in favor say aye.
Aye.
Aye. Okay, is there a motion to the bill? It's,
Ought to pass as amended.
okay, Senator Chanley moves ought to pass
I'll
as
second.
amended, seconded by Senator Whitley. Is there any further discussion on the bill as amended? Okay, seeing none, all in favor say aye.
Aye.
Any opposed? Okay, is there a motion for the consent calendar?
So moved.
Second.
Moved by Senator Chandley, seconded by Senator Whitley. Is there any discussion on the consent calendar motion? Seeing none, all in favor say aye.
Aye.
Any opposed? Okay. Senator Whitley, you want to do this one?
Sure.
Did you have the amendment? Okay.
Cam told us in HHS that we're not allowed to leave the building.
Oh, you better listen to that. Okay, so this is, all right.
Moving right along.
Yeah, we're getting there. We are 182, we've decided we're gonna hold till next week. Senate Bill 183, exempting certain phone calls. I think we've decided to kind of hold that one
Oh,
as
okay.
well,
Okay.
because it's not a fiscal note bill.
Okay.
Senate Bill 184.
I move on to pass.
Okay, hold on. I knew this was gonna happen. All right, we have a motion of ought to pass from Senator Whitley. Is there a
Second.
second? Seconded by Senator Chamley. Okay, so discussion.
Yeah, I think this is a good bill. I think, we're at a situation where last week we had 18 kids waiting in ERs for psychiatric care. They're waiting, they're not getting care. 18 kids. This week we had 15 kids. So I think no one problem was going to solve the children's mental health crisis, but we need to take those steps, add tools to our toolbox to address the problem. That's what NAMI keeps telling us. So I think this is just one other tool that we can get. In a perfect world, of course, parental, we would get that consent, but the reality is we know that that's not the situation for every family. And that's very sad to me that this is even necessary, but I do think it is necessary.
Right.
And if I might just
Senator
add to,
Chandler.
thank you, Madam Chair. And if I might just add to that, it is essential, and not only for the reasons that Senator Whitley stated, for many of the reasons we heard at the public hearing, but also for the reasons, the support that this bill has.
Senator Chamley, can I just ask you, ladies in the back, please, we can hear you. So please keep the noise down. Senator Chamley.
So I think this bill has garnered support from some very trusted folks, such as the child advocate from the Office of the Child Advocate, and some of the other people who deal with mental illness, and particularly the repercussions of mental illness and untreated mental illness among teens. Thank you.
Thank you. Okay, is there any further? Senator Abbas.
Thank you, Madam Chair. I'll be opposing the ought to pass motion. And one concerning part of this bill is it's not just the lack of consent that a parent has for the child receiving mental health treatment, but if a parent finds out about the medical treatment that they're getting and then objects to it, the parent, even though the child's a minor, has no control or no discretion, no parental discretion at all on how that should be handled. And it can, even if that objection is as simple as having someone, not in there covered by their health insurance. We passed a different bill, I think on consent, where if we have to, with the court, if they're going to require mental health treatment, it would have to be something provided that's under your own health insurance. So we're not addressing any of it. And I just look at it as the parents still have the rights to make those parental decisions, and this is taking that away, even after the fact. And I can't support it.
Okay, so is there any further discussion on the ought to pass motion? Okay, seeing none, all in favor say aye.
Aye.
Opposed?
Nay.
Nay.
I'd
Okay,
like to introduce a new motion by TL.
okay, the ought to pass fails, and
Second.
we have I can't even,
Motion.
a motion to ITL, moved by Senator Abbas, seconded by Senator Gannon. Is there any discussion on the ITL motion? Okay, seeing none, all in favor say aye. Aye.
Aye.
Any opposed?
No.
Okay. Senator Abbas, do you want to take this one out? Okay, next we have Senate Bill 244 relative to false
I
alarms.
move on to pass.
Second.
Okay, we have a motion about to pass, and we have a second. We do have an amendment from Senator Abbas. Senator Abbas, would you like to discuss your amendment?
I would, I'm having trouble finding it, but it's very straightforward. So I can't name the amendment number off the top of my head. I'm sure someone else has.
0547S. It wasn't sent out.
Probably over there.
I just have my copy.
Tell them what it says with that.
We can have Gabrielle make copies and then we can come back to it.
Well, and all it does is just, not to ruin the surprise, it adds a bomb threat as well.
That's what?
It adds a bomb threat, and
Okay.
we would like to say any type of threat of any explosive device.
Yeah, so we
being
might need just a committee amendment just to refine that. We can hold off and do this one last.
Okay.
So that way people will have an opportunity to look at it. Next, we have Senate Bill 248 FN. I'm going to make a motion to re-refer this bill.
Second.
Seconded by Senator Gannon. We've got a number of bills dealing with this particular issue. As you know, we don't always know what's going to happen over in the House. So I would like to keep this one, so we will have a vehicle. So I have the motion to refer this bill back to committee. Is there any further discussion? No? Okay. All in favor say aye. Aye. Any opposed? Okay. Can I get a motion for the
Move
consent?
consent.
Second.
Moved by Senator Chanley, seconded by Senator Whitley. Is there any discussion? Okay. Seeing none, all in favor say aye. Aye. Any opposed? Okay. Senator Abbas, would you like to do this one as well? It's your bill.
Yes.
Okay, just write the little blue thing. Okay. Next, we have Senate Bill 249, relative to the release of a defendant pending trial. I'd like to move on to pass. Seconded by
Second.
Senator Abbas. Is there any discussion? Senator Whitley.
Yeah, thank you. So I think there was a lot of confusion around this bill. I think, I think when Senator Abbas described what he wanted to do, I got it, but I don't think that the bill itself addressed that problem. I think it was a little bit confusing, and I think we heard that confusion from our testimony as well. So I don't think I can support not to pass on that.
Senator Abbas.
Thank you, Madam Chair. So this language, or virtually identical language, has passed this body more than once last term. So I don't want to take the credit for the language here that's in the bill. It's been discussed in great length by both bodies last term. And
Sorry.
to me, this actually clarifies the existing law. There's already the rebuttable presumption that exists under existing law if someone violates the conditions of their release. This provision, what it says, if you are released on bail and you commit a new offense, whether it's a Class A misdemeanor, drunk driving, or a felony, and you get released the second time, if you were to be charged with a third offense, again, a Class A misdemeanor, drunk driving, or a felony, and we are excluding Class B misdemeanors because, with the exception of drunk driving, the reason being that if you're not going to serve a jail sentence for the crime itself, why should your bail be revoked? This is now the third time someone's been arrested while they have two other open cases now. And I will emphasize that if someone is continuously violating the conditions of their release, I'm not sure why we have any confidence that they will honor those conditions, but there has to be consequences for this. Otherwise, the conditions don't have any real purpose. And this is accountability for someone who's committing multiple offenses time and time again in a relatively short period of time. And I hope to support the ought to pass. There's a lot of resources that are used by law enforcement, by cities and towns, even the state police constantly having to address repeat offenders who are not taking any accountability for their actions. This will hold people accountable for their conduct when they commit multiple offenses in a short period of time. Thank you.
Okay, thank you. Is there any further discussion on Senate Bill 249? Okay, we have an ought to pass motion. Okay, all in favor say aye. Aye. Any opposed?
No.
Okay. This is going to be Senator Abbott's day.
It is.
Okay. Okay, the next bill we have, Senate Bill 252, relative to release of a defendant pending trial.
Motion not to pass.
Okay, we have a motion of ought to pass. Is there a second? Okay. So is there any discussion on the ought to pass motion? Yes, please.
This is the identical one to 248 that
Yep.
we just held, right?
Yeah.
And, you know, this is the third time maybe that we've seen an identical bill. And I want to say categorically that I don't think dangerous people should be released. Like we need to start there. It's not a question about whether whether people think that dangerous people should be released. I think I absolutely agree with that. And that's an issue that we need to fix. It's problematic for our communities and it makes me scared, right, as a mom. But unfortunately, I don't think this bill is the solution to that. I think we're overshooting a little bit because, and the reason why I'm uncomfortable with it is it results in that automatic incarceration, as we know, for potentially several days prior to arraignment. And I think when we're removing someone's liberty, like we're talking about, removing someone's liberty, when we're doing that, we really have to think long and hard about whether that's the precision, that long and hard about, if that's the right way to do this, right? We're talking about something that New Hampshire cares deeply about, which is liberty and freedom. And we want to have the fix be precise. And I just don't think this is the precise way to do that because we're just going to sweep in a lot of people. And what we hear is that we're going to sweep in all these people who we know whose charges are eventually dropped. We heard a startling statistic about how many people whose charges are dropped and later proved innocent. So I'm just concerned again about the collateral harm by this sweeping solution. We know the collateral harm is folks losing their jobs, families, all that. And I think, we have heard some really big problems about what's happening in our communities, and I'm really concerned about that. And I think what I heard from the testimony, and I haven't heard anything, what remains confusing to me is why we aren't fixing the actual problem, which is that people aren't implementing the current statute. And I even asked Senator Susi this, is it with implementation or administration? And the answer is yes. And so I don't think, we're hearing about dangerous people being released because the tools in the current law aren't being used. And so I'm concerned with a fix that's going to remove people's freedom when we're not even implementing the current law. And I think that's problematic. So, this is a tough issue, and I know, we'll continue to have conversations with that. I know safety is a huge problem in our community, but I don't think this is the right solution.
Thank you. Are there any further comments? Senator Abbas.
Thank you, Madam Chair. There was one question asked about whether during the public hearings about does the existing law address solve this problem? Does it give the option to the county attorney to bring or have a dangerous hearing upon request, or can they appeal or challenge the finding made by the bail commissioner? The problem with that specific issue is if they want to do that, the hearing's going to be within 48 hours of the bail commissioner's decision. If that person is a dangerous person, well, that person's already been released and has now been released to the public. So the current procedure to challenge the bail commissioner's finding, I believe, is glaringly insufficient to address public safety concerns. And so that's why this is now eliminating the requirement for the bail commissioner. We're talking about violent crimes where the victim is a person, so with domestic violence, human trafficking, and some of these severe crimes was the result of a very thorough investigation. And we're talking sex crimes against children, so like child pornography. In those cases, there's often, to get a warrant, there's already been a very detailed investigation that has been done. So what we're doing here is we're addressing some of the most violent crimes we can find, and obviously sex crimes involving children. And in those cases, there will be they'll still have a bail hearing, but it will be before a judge, not a bail commissioner. And it will be within a reasonable time period. Our court's on open the weekend. We can't solve that here today. But when you have a public safety concerns, those need to be addressed. And you have people, we heard testimony where people have been victim of a violent crime by the same person twice in the same day because the person's being released by a bail commissioner and then being a victim now for the second time. And in the second offense, and this is common with domestic violence, it tends to elevate. And that's what we had happen. We had a person be a victim of domestic violence. The person was released from bail. Then the person broke into her house and sexually assaulted her. So we're trying to avoid situations like that. And I think we're trying to address the most egregious situations without actually overturning the bail reform that passed a few years ago.
Okay, yes, please.
Yeah, and I hear you, Senator Abbas. I understand that issue of, that the bail commissioner is sort of gets the first crack at it. And I think, again, like, I think we're agreeing on the problem. I think we're disagreeing about the solution. I see a solution to what you're describing is, I think there's a bill over in the House, 46 maybe, that, where people go in front of a magistrate, in front of a bail commissioner. That would address the issue that you're talking about, because, even the current law, you have this tool that prosecutors aren't using, and I don't know why they're not using it. That's a concern of mine. But again, I think we're agreeing on the problem. I think all of us are agreeing on the problem. I think we're just disagreeing about the solution. And the reason why I'm so uncomfortable with it is this notion of holding people, until they've been proven guilty, when we know how many people the charges get dropped. We know how many people ended up proved innocent. We're taking away their liberty before anything happens. So it seems to me that to address your concern, something like HB 46 might be the better approach.
Yes, Senator.
Just to clarify though, that this does not hold someone until they've been proven not guilty.
No, that's not what I said. Yeah, no.
Or they're not being held till proven guilty. They're being held
If
pending.
they're being held before they are being, right?
But that logic would apply to any time you have hold someone awaiting an arraignment. And any type of bails, even if anyone who gets bail for any offense hasn't been proven guilty yet and they're waiting their trial. So under that line of
No,
thinking.
it's on balance, right?
Okay,
You're
hold
taking
on.
away someone's
Well, we
liberty.
shouldn't be arguing back and forth with each other. If we want to come, we'll go through the chair, please, rather than going back and forth with each other. Okay, are there any further comments? Senator Chanley?
Thank you, Madam Chair. I don't want to unnecessarily prolong the discussion, but there are good points being raised, and I can't agree more with Senator Whitley that it's a complex problem that involves infrastructure and administration, and I think we need to really keep our eyes on that. I do, however, I will support the ought to pass motion because I do think this is a way we can address some of the problems that are occurring. But I think we need to, from the get-go, pay very close attention to the outcome, should this pass and be signed into law, whether this is in fact doing what we're intending it to do. And we really need to re-examine again and again, as we have, because that's why there's been 3 and 4 and 5 times we've addressed this. We need to make sure that the consequences of this are not unintended.
Thank you very much, Senator Chanley. Are there any further comments? Okay, seeing none, we have an ought to pass motion on Senate Bill 252. All in favor say aye. Aye. Any opposed?
No.
Okay. Daryl, I'll take, I was going to say, Senator Abbas, I'll take this one out. Okay. Next, we have 255. We just heard this one on Tuesday.
Yeah.
I don't think we should do that. I think folks might need a week or so to digest what this is, so we can hold off till next week. And the last one we have is Senate Bill 262, relative to parentage. I don't know if anybody has, I know Senator Gannon has a proposed amendment. Senator Perkins Polka also has an amendment to repealing the rulemaking. I'd like to see if we can just hold off on this one, because I think there were some other issues. And hopefully, Senator Perkins Polka can maybe reach out to the folks and see if we can get some sort of resolution on this.
Yeah, she let me know today that her group is working very, very, very hard to come to consensus on a good.
Okay,
Yeah, so she will. She's promising it in a timely way.
okay. The last one we have is Senate Bill 244. Everyone has received a copy of the amendment. You can see where Senator Abbas has inserted on lines 8 and 9 the presence of a bomb. Did you want to address that, Senator Abbas?
Thank you, Madam Chair. Yes, and when I was reading this, when I printed it out, I was thinking that it should say bomb or in an explosive device, which I know would include a bomb, but I think we just want to make sure we're kind of making a pressure cooker may not be a bomb, but it could, as you know, anything from history that can be served in a similar capacity.
Senator Chandler.
Thank you very much. My only question, I'm completely fine with the idea of including explosive device. I'm wondering if, and perhaps it is a fine word, but bomb, I'm just a little, is that too loose a word?
Explosive.
If, I know there are 3 lawyers on the committee.
Yeah.
Lawyer for,
Me.
so there are 4 lawyers here, and if bomb is a fine word, I'm fine going along with it. That seems.
You know, I'm kind of thinking about when I was high school, kids sometimes would have stink bombs.
Stink bomb's exactly what I was thinking, and that was my concern. That's
Yeah.
exactly what I was thinking.
Yeah, so we're talking, so Senator Abbas, would you be amenable to having it say the presence of an explosive device versus bomb?
Which I believe, in my understanding, explosive device would include a bomb.
Okay,
Yeah, but there are things called a big bomb.
No, I'm aware.
Yeah.
I never use one, but I understand.
it's just kids doing hijinks, that's all.
If that's fine, I'm totally,
Okay, so Matthew, we will need a committee amendment to Senate Bill 244. That will change some language beginning on line 8. It says the presence of an active shooter, comma, the presence of an explosive device instead of bomb. Okay? So we have a proposed committee amendment to Senate Bill 244. Is there a motion on that amendment?
Pass.
Okay, passed by Senator Gannon, seconded by Senator Chandler. Is there any discussion on the proposed committee amendment? Okay, seeing none, all in favor say aye.
Aye.
Okay, any opposed? Okay, is there a motion on the bill as amended?
I move on to pass as amended.
Senator Chandler moves, Senator Whitley moves
Second.
on to pass as amended, seconded by Senator Chandler. Is there any discussion on the bill as amended? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed? Okay, is there a motion for the consent calendar?
move consent.
Second.
Moved by Senator Chandler, seconded by Senator Whitley. Is there any further discussion on the consent calendar motion? Okay, seeing none, all in favor say aye.
Aye.
Aye, any opposed? Okay, who would like to take this lovely up? Senator Chandler. Okay, we are finished. Can I get a motion to come out of executive session? Moved by Senator Whitley, seconded by Senator Chandler. Good luck, Senator.
Thank you. I'm gonna
Whitley.
run.
Yeah.
Don't
Just
need to vote and run. but-
no, it happens. I'm going to work with Matthew to come up with a list of the bills we have left and really emphasize the bills we have to get rid of on Tuesday.
Okay, great.
So everyone will know what we're doing. So
Right.
have a great weekend, everybody,
you.
and thank you. Bye-bye.
Alrighty.
Okay.